Αγαπητοί συνάδελφοι, φίλες και φίλοι, καλή εβδομάδα. Σας ευχαριστώ πάρα πολύ που είστε παρόντες και σήμερα σε αυτή τη διάλεξη του κύκλου Διαλέξεων για τη Διαμεσολάβηση που σας προσφέρουμε η Ελληνική Ένωση και ο ΟΠΕΜΕΔ σε συνεργασία. Την σημερινή διάλεξη μας κάνει την τιμή και μας δίνει τη χαρά να παρακολουθεί ο Πρόεδρος της Επιτροπής Νομικών Θεμάτων της ΚΕΔ, ο κύριος Κυριάκος Οικονόμου, αρεοπαγίτης επιτιμή, τον οποίο ευχαριστώ πάρα πολύ και προφορικά από αυτή τη θέση που είναι σήμερα παρόν και ελπίζω να είναι επίοικης μαζί μας. Κύριε Πρόεδρε, καλώς ήρθατε. Αγαπητοί συνάδελφοι, η σημερινή διάλεξη είναι η πέμπτη του δεύτερου κύκλου των κύκλων διαλέξεων για την διαμεσολάβηση. Ευχαριστούμε πάρα πολύ όλους όσους είστε παρόντες. Ξέρω ότι είστε παρόντες σε όλες τις διαλέξεις, ότι είστε πιστοί. Οι σημερινοί είστε πάρα πολύ πιστοί και παρόντες σε όλες τις διαλέξεις. Δεν θέλω να σας απασχολεί το θέμα ότι κάποιες διαλέξεις γίνονται στην αγγλική γλώσσα, διότι έχουμε αποφασίσει, παρόλο που κάθε φορά ρωτούσαμε και κάθε φορά λαμβάναμε την απάντηση ότι δεν χρειάζεται μετάφραση, σήμερα αποφασίσαμε, χωρίς να σας ρωτήσουμε, ότι θα κάνουμε μετάφραση έτσι να είναι βέβαιο ότι όλες οι έννοιες γίνονται αντιληπτές, διότι ιδίως όταν μιλούν συνάδελφοι από χώρες οι οποίες έχουν διαφορετική ρύθμιση, νομοθετική ρύθμιση και πρακτικές διαφορετικές σχετικά με τη διαμεσολάβηση σε σύγκριση με την Ελλάδα και εν γέννη τις ευρωπαϊκές χώρες, είναι καλό να αντιλαμβανόμαστε ακόμα και την πιο μικρή λεπτομέρεια. Σήμερα δεν θα σας κουράσω καθόλου παρουσιάζοντας την Ελληνική Ένωση Διαμεσολαβητών. Είμαι βεβαία ότι θυμάστε όλοι ποιοι είμαστε και τι κάνουμε. Ούτε για τον ΟΠΕΜΕΔ θα σας πω ιδιαίτερα κάτι, διότι και τον ΟΠΕΜΕΔ τον γνωρίζετε πολύ καλά και πολλές φορές μου έχει δοθεί η ευκαιρία να αναφερθώ στον ΟΠΕΜΕΔ. Εκείνο το οποίο θέλω να σας πω είναι να ξέρετε ότι στόχος και της Ελληνικής Ένωσης Διαμεσολαβητών και του ΟΠΕΜΕΔ είναι να διευκολύνει τους συναδέλφους διαμεσολαβητές, να προάγει την διαμεσολάβηση, να διαδώσει τη διαμεσολάβηση για να γίνει αυτή αντιληπτή 100% από τους διαμεσολαβητές και αν είναι δυνατόν να μεταδοθεί, να μεταλαμπαδευτούν οι γνώσεις περί διαμεσολάβησης από όλους εμάς και στους πολίτες. Προσωπικά κάνω αναρτήσεις της πρόσκλησης κάθε διάλεξης και σε άλλους ιστότοπους, εκτός από τους ιστότοπους για τη διαμεσολάβηση, σε ιστότοπους διαφόρων δήμων, φύλων, έτσι ώστε να μπορέσουμε να έχουμε τη δυνατότητα να ενημερώσουμε και τους πολίτες. Ουσιαστικά δηλαδή κάνουμε με αυτές τις διαλέξεις το έργο το οποίο κάναμε στην πύλη διαμεσολάβηση, στην οποία ανοίξαμε τον Ιανουάριο του 2019, όπως σας έχω πει κατ' επανάληψη, στο Δημαρχείο της Κηφισιάς που θέτει στη διάθεσή μας μία αίθουσα, την οποία δυστυχώς δεν έχουμε μπορέσει να χρησιμοποιήσουμε από τον Μάρτιο του 2020 μέχρι σήμερα. Η πύλη βέβαια παραμένει ανοιχτή, με την έννοια ότι μόλις τελειώσει σύν Θεό και με το καλό αυτή η πανδημία, θα μπορέσουμε να τη χρησιμοποιήσουμε και πάλι. Το κλείσιμο, η έλλειψη δυνατότητας να πηγαίνουμε στην πύλη διαμεσολάβησης αποτέλεσε για μένα το έναυσμα για να σκεφτώ να κάνουμε αυτές τις διαλέξεις, οι οποίες ίσως και σε τελευταία ανάλυση είναι και πιο αποδοτικές. Εκείνο που θα ήθελα να πω πριν σας παρουσιάσω τον σημερινό ομιλητή είναι το εξής. Θέλω να επιστήσω την προσοχή όλων των συναδέλφων ότι είναι απαραίτητο να κατανοήσουν ότι στόχος του νόμου, στόχος όλων των φορέων είναι να διαδοθεί η διαμεσολάβηση και όχι να γίνει σωστά η ΙΑΣ. Παρατηρώ από τηλεφωνήματα που δέχεται η Ελληνική Ένωση Διαμεσολαβητών, από ερωτήσεις οι οποίες τίθενται, από chat τα οποία γίνονται σε διάφορα φόρα και ανταλλάσσονται απόψεις, παρατηρώ ότι οι περισσότεροι συνάδελφοι, η πλειονότητα, είναι, επιτρέψτε μου την έκφραση, γαντζωμένοι στην ιάς και την απασχολούν την πλειοψηφία αυτή μόνο τα πρακτικά θέματα της ιάς. Το σέβομαι, υποκλίνομαι. Υπάρχουν πάρα πολλές δυσκολίες στο να εφαρμοστεί μια καινούρια διαδικασία. Η ιάς είναι κάτι το οποίο εισήχθη πρώτη φορά τον Νοέμβριο, τέλος Νοεμβρίου μάλιστα του 2019. Δεν είναι ένας χρόνος και κάτι. Και με το lockdown που είχαμε, πολλές περιόδους δεν εφαρμόστηκε η ιάς. Κατά συνέπεια είναι κάτι το καινούριο, κάτι το νέο, το οποίο είναι φυσιολογικό να δημιουργεί προβλήματα. Είμαστε στη διάθεσή σας, το γνωρίζετε. Υπάρχει η Επιτροπή Νομικών Θεμάτων της ΚΕΔ. Σας είπα ότι ο πρόεδρος της μας κάνει τη τιμή και μας δίνει τη χαρά σήμερα να μας παρακολουθεί. Μην διστάζετε να απευθύνεστε στην Επιτροπή αυτή για να λάβετε μία έγκυρη γνώμη. Αφήστε τους βυζαντινισμούς. Τι και πώς και γιατί και αν τα δικαστήρια θα λάβουν υπόψη αυτά που λέτε με βάση τις γνώμες της Επιτροπής, όλα αυτά είναι φλιαρίες. Παρά να ανταλλάσσετε απόψεις οι οποίες είναι συγκρουόμενες και πάρα πολλές φορές σας μπερδεύουν ακόμη περισσότερο, να απευθύνεστε στην Επιτροπή Νομικών Θεμάτων της ΚΕΔ. Και εκείνο το οποίο θέλω να υπογραμμίσω άλλη μία φορά, το είπα και την προηγούμενη φορά, το λέω με μεγαλύτερη έμφαση σήμερα. Μην ξεχνάτε, σας παρακαλώ, ότι η ιάς είναι ένα εργαλείο για να μπορέσει να φτάσει η διαφορά σε εκούσια διαμεσολάβηση, με την ευχή να μπορέσει να βρεθεί από τους ενδιαφερόμενους μία λύση, η λύση που θεωρούν την καλύτερη και πιο ενδεδειγμένη για αυτούς μέσω της διαμεσολάβησης. Αυτός είναι ο στόχος της ιάς. Δεν είναι ο στόχος ούτε πώς θα συμπληρώσουμε τα διάφορα έντυπα, ούτε πώς θα τα στείλουμε, ούτε πώς θα τα βάλουμε, ούτε εάν η ιάς διακόπτει την παραγραφή. Στο σημείο αυτό επιτρέψτε μου να πω και κάτι άλλο. Παρατηρώ ότι τίθενται πάρα πολλές ερωτήσεις στις μεταξύ σας συζητήσεις, οι οποίες απαντώνται με μία απλή ανάγνωση του νόμου. Διαβάστε τον νόμο πριν πέσετε στην παγίδα της απορίας και του προβληματισμού μπροστά σε κάτι καινούριο. Σας ευχαριστώ πάρα πολύ που με ακούσατε. Ελπίζω η παρένεσή μου αυτή να έχει καταλήξει σε ευήκοα ότα και να ληφθεί υπόψη. Μετά από αυτά θα σας παρουσιάσω τον σημερινό ομιλητή μας, ο οποίος είναι ο κύριος Colin από την Καλιφόρνια των Ηνωμένων Πολιτειών. Colin, would you please excuse me if I present you in Greek?
No, thank you.
I think I will do it better if I present you in Greek. Okay, thank you. Λοιπόν, ο κύριος Ρουλ είναι ούτως υπήν εκείνος ο οποίος δημιούργησε την διαδικτυακή διαμεσολάβηση. I say, Colin, that you are the one, in fact, who have created online mediation.
Okay, I'll let you say that then, without contradiction.
This is why I wanted to speak in Greek, because I knew that if I said it in English, because you do not want me to say many things, which I know from personal experience. Λοιπόν, ο κύριος Ρουλ, τον οποίο γνώρισα το 2013 σε ένα συνέδριο στην Πράγα, όπου είμαστε μαζί σε ένα πάνελ για την διαδικτυακή διαμεσολάβηση. Αντιλαμβάνεστε ότι εγώ είχα διαβάσει πάρα πολύ, είχα γράψει την εισήγησή μου, αλλά βέβαια δεν γνώριζα και πολλά πράγματα για την διαδικτυακή διαμεσολάβηση. Ίσως εκείνη ήταν η ευκαιρία που μου επέτρεψε να μάθω κάποια πράγματα. Ο κύριος Ρουλ κάτι του είχε προκύψει και δεν μπόρεσε να είναι παρόν εκείνη την ημέρα στην Πράγα και εμφανίστηκε λοιπόν σε μια τεράστια οθόνη στον τοίχο και μας μιλούσε από εκεί και αυτά τα οποία μας έλεγε μας εντυπωσίασαν τόσο πολύ που του είπαμε καλά, δηλαδή τι θέλεις να μας πεις, ότι σε λίγα χρόνια όλα θα γίνονται διαδικτυακά, everything will be virtual? Και ο κύριος Colin απήντησε ναι. Και αυτό ήταν μια πρόβλεψη, μια πρόγνωση, είχε την αίσθηση, είχε τη διαίσθηση, πάντως βγήκε αληθινός. Σε κάθε περίπτωση, οφείλομαι πάρα πολλά στον κύριο Colin για την εξέλιξη της διαδικτυακής διαμεσολάβησης. Θα σας διαβάσω εν συντομία το βιογραφικό του κυρίου Colin, το οποίο είναι πάρα πολύ σημαντικό βέβαια, αλλά θα σας πω τα κυριότερα πράγματα για εκείνον, πολύ περισσότερο που ο κύριος Colin είναι πάρα πολύ σεμνός και δεν επιθυμεί να λέμε πάρα πολλά πράγματα για εκείνον. Λοιπόν, σήμερα ο κύριος Colin Rule είναι ο Διευθύνων Σύμβουλος του mediate.com. Είμαι σίγουρη ότι όλοι γνωρίζετε το mediate.com, διότι διοργανώνει διάφορες εκδηλώσεις, διάφορα σεμινάρια, τα οποία έχουμε την ευκαιρία να παρακολουθήσουμε όσοι θέλουμε. Λοιπόν, ο κύριος Colin Rule είναι σήμερα ο Διευθύνων Σύμβουλος. Το 2011 είχε δημιουργήσει έναν άλλον ιστότοπο με το όνομα modria.com. Αυτός ο ιστότοπος ήταν ένας πάροχος ODR, Online Dispute Resolution, τον ξέρετε τον όρο, που με έδρα τη Silicon Valley στην Καλιφόρνια. Το 2017 εξαγοράστηκε από μια εταιρεία ονόματι Tyler Technologies. Από το 2017, όταν αγοράστηκε αυτή η εταιρεία μέχρι το 2020, ο Colin ήταν αντιπρόεδρος για ODR σε αυτήν την εταιρεία. Βεβαίως δεν θέλησαν να τον αφήσουν να φύγει, διότι ήταν βασικός πυλώνας τους. Από το 2003, πηγαίνουμε πίσω τώρα, μέχρι το 2011, ο Colin ήταν διευθυντής ODR στο eBay και το PayPal. Πιστεύω ότι γνωρίζετε το eBay και το PayPal, που είναι ιστοσελίδες από τις οποίες μπορούμε να αγοράζουμε αντικείμενα και υπηρεσίες. Και αυτές οι δύο πλατφόρμες, μάλλον όχι ιστοσελίδες, αυτές οι δύο πλατφόρμες είναι εκείνες οι οποίες δημιούργησαν την ανάγκη να ασχοληθεί η Ευρωπαϊκή Ένωση με τα θέματα της επίλυσης διαδικτυακά των καταναλωτικών διαφορών, οι οποίες πολύ συχνά δεν έχουν αρκετά μεγάλο αντικείμενο ώστε να δικαιολογείται η δικαστική διαδικασία, η οποία στοιχίζει ακριβά, ιδίως στην Αμερική, και πάρα πολύ συχνά οι καταναλωτές εγκατέλειπαν τις απαιτήσεις τους κατά του πολιτή, λόγω του μικρού αντικειμένου, λόγω του ότι βρίσκονταν σε άλλη χώρα ο πολιτής, σε άλλη χώρα ο αγοραστής, και έτσι δόθηκε η αφορμή για να ασχοληθεί, όπως είπα, η Ευρωπαϊκή Ένωση με την ηλεκτρονική επίλυση των καταναλωτικών διαφορών, εκδίδοντας και σχετική οδηγία. Ο κύριος Ρουλ έχει γράψει 2 βιβλία, το ένα εκ των οποίων λέγεται Online Dispute Resolution for Business. Είναι η διαδικτυακή επίλυση επιχειρηματικών διαφορών. Το άλλο, το οποίο το έγραψε μαζί με κάποιον άλλον συγγραφέα, λέγεται The New Handshake, ODR and the Future of Consumer Protection. Η καινούργια χειραψία, ODR και το μέλλον της προστασίας του καταναλωτή. Ο κύριος Ρουλ από το 1999 ήταν διευθύνων σύμβουλος και πρόεδρος της πρώτης διαδικτυακής, ο κύριος Ρουλ ίδρυσε το Online Dispute Resolution, μία από τις πρώτες πλατφόρμες για την διαδικτυακή επίλυση διαφορών, και το 1999 ίδρυσε αυτή την πλατφόρμα και υπήρξε διευθύνων σύμβουλος και πρόεδρος της. Ο κύριος Ρουλ για πάρα πολλά χρόνια συνεργάζεται με το National Institute for Dispute Resolution στην Ουάσιγκτον και το Consensus Building Institute στο Cambridge. Αυτά τα λίγα λόγια για τον κύριο Ρουλ, ο οποίος επαναλαμβάνανε πάρα πολύ σεμνός και δέχτηκε αμέσως, δηλαδή ήταν κάτι το οποίο με εξέπληξε πολύ ευχάριστα. Έχει τόσο φορτωμένο πρόγραμμα και δεν δίστασε ούτε λεπτό να αποδεχθεί την πρότασή μου, να μας κάνει αυτή τη διάλεξη. Θα τον ακούσουμε σήμερα και θα του κάνουμε όσες ερωτήσεις θέλουμε, διότι μας είπε ότι είναι απόλυτα διατεθειμένος να απαντήσει σε ό,τι ρωτήσουμε. Colin, once again, I thank you very much for being today here with us. I know that your program is overloaded, which makes the acceptance of my invitation even more important for us. Thank you again. Welcome, and you have the floor.
Oh, thank you, Catherine, so much. And I so appreciate your invitation to present this morning. I'm delighted to be here with all of you. Good evening to all of you, even though it's good morning here in California. And thank you, Sergio, for setting us up so capably. Yes, thank you also for such a thorough bio. I'm realizing now, Catherine, my Greek is terrible. I didn't understand anything you said except for the words you said in English. But there's something about hearing your bio in Greek. It sounds very impressive. So I appreciate the kind introduction. So it's very nice to see all of you. Thank you for taking the time. This is actually, the perfect way to talk about online dispute resolution is through Zoom, because this is the way we have to interact with each other these days. Sergio was telling me in Athens, there is a rule that you have to be home by 6 p.m. So I guess that's when the Zoom begins. You know, that is how we interact with each other now. It's amazing to me that even little children in schools, this is now how in the United States, they're getting access to their classes. So it's very interesting, all of the things that we need to do in dispute resolution to provide services via technology. So let me start sharing my slides. Catherine and I have agreed I will break every once in a while for her to do some translation, but I am very eager to hear from all of you. If you have any thoughts or questions, please don't hesitate to use the raise hand option in Zoom, and then you can break in anytime. As Catherine mentioned, I have way too many slides for the time we have today, so we're not going to get through all of them, but we'll see where they lead us. So let me click the buttons here. I think Sergio made me a co-host, so this should work. All right. So hopefully you're now looking at a screen that says mediate.com online dispute resolution. Catherine, can you see that? Give me a thumbs up if yes.
Yes. Yes,
okay,
yes.
Great. Excellent. So let me move forward here. And I think my guess, even though I didn't understand the Greek, is this is what you've already addressed, Catherine. So I will not spend too much time on this. But as we know, society is digitizing. The world is digitizing. Business, education, government, everything is moving on to the internet very quickly. And when I first started doing this work in the late 90s, the internet was growing very quickly, but we did not yet have iPhones. We did not yet have Facebook. We did not yet have Zoom. And now we have all of these things, and they have become the new normal. So what I've always said is, if you are not moving your work online, you are risking irrelevance, where your parties, because they live online, they will not find you, and they will not ask you to help them. Now, the pandemic has made this truer than ever before. We have to move our services online if we are going to meet our parties where they are. So, Catherine, please.
Thank you, Colin. Ο Colin μας λέει ότι τα πάντα ψηφιοποιούνται σήμερα στις ημέρες μας. Ο ίδιος ξεκίνησε από το τέλος της δεκαετίας του 1990 να ασχολείται με την ψηφιοποίηση και με την παροχή υπηρεσιών μέσω του διαδικτύου. Τότε όμως δεν είχαμε, λέει ο Colin και πάρα πολύ σωστά, θα το θυμάστε όλοι, δεν είχαμε κινητά τηλέφωνα, δεν είχαμε Facebook, δεν είχαμε Zoom, κυρίως Zoom, το οποίο έχει κατακτήσει τα πάντα. Σήμερα προστιθεμένης και της πανδημίας και του εγκλισμού, είναι απαραίτητο όλοι να γνωρίζουμε, να ξέρουμε να χρησιμοποιούμε τα ψηφιακά μέσα, να μπορούμε να ανταποκρινόμαστε διαφορετικά. Εάν δεν μπορούμε, δεν θα μας βρει κανείς για να μας αναθέσει. Σήμερα οι διαμεσολαβήσεις όλο και περισσότερο γίνονται και πρέπει να γίνονται διαδικτυακά εκ των πραγμάτων. Λοιπόν, εάν δεν είμαστε εξοικειωμένοι με το ίντερνετ, με το Facebook ο λιγότερο, με το Zoom κυρίως που είναι εκείνο η πλατφόρμα που προτιμάτε, δεν θα μπορεί να μας βρει κάποιος για να μας αναθέσει την υπόθεσή του. Δεν θα μπορούμε να επικοινωνήσουμε. Σε προσωπικό επίπεδο ο εγκλισμός, αυτό το lockdown τέλος πάντων, θα είναι ακόμα πιο δύσκολος, διότι μετά ψηφιακά μέσα μπορούμε να επικοινωνούμε με τους συγγενείς, την οικογένεια που δεν βλέπουμε όταν είναι σε άλλη πόλη, με τους φίλους μας να κάνουμε. Προσωπικά κάνω ακόμα και το μάθημα γιόγκα μέσω του Skype και τώρα βέβαια τα πράγματα έχουν εξελιχθεί πάρα πολύ και με μεγάλη ταχύτητα αναπτύσσεται αυτή η ανάγκη να είμαστε εξοικειωμένοι με όλα τα διαδικτυακά μέσα. Thank you, Colin.
Thank you, Catherine. So, online dispute resolution is the use of information and communications technology to help disputants resolve their disputes. Now, also, ODR can be used to prevent disputes from arising in the first place, and it can also help to manage disputes that are not easily resolved, but they need to be controlled. So ODR is the same thing as ADR, face-to-face ADR. It's just the use of information and communications technology to assist ADR. So Catherine, do you want to translate that?
Thank you. Το ODR, δηλαδή η διαδικτυακή επίλυση διαφορών, συνίσταται στην χρήση του διαδικτύου και των...
Μάλιστα. Ναι. Έλα.
Παρακαλώ τα μικρόφωνά σας. Είναι η χρήση, λοιπόν, έλεγα, το ODR, της πληροφορίας και των επικοινωνιών, της τεχνολογίας για την πληροφορία και τις επικοινωνίες, προκειμένου να βοηθούνται ή τα αντίδικα σε εισαγωγικά μέρη να βρίσκουν λύσεις στις διαφορές τους. Όμως το ODR μπορεί να χρησιμεύσει όχι μόνο για την επίλυση διαφορών που έχουν ήδη προκύψει, αλλά και για την αποτροπή του να δημιουργηθούν, να προκύψουν διαφορές, καθώς επίσης και για τον χειρισμό δύσκολων διαφορών, οι οποίες δεν μπορούν να επιληθούν, αλλά πρέπει να ελεγχθούν. Στην πραγματικότητα το ODR είναι το ίδιο με το ADR, Alternative Dispute Resolution, που είναι πρόσωπο με πρόσωπο, ενώ το ODR, Online Dispute Resolution, είναι η διαδικτυακή επίλυση των διαφορών. Thank you, Colin.
Great. So the National Center for State Courts, which is advocating for online dispute resolution within the US courts, they have a different definition. Their definition is that ODR is a public-facing digital space in which parties can convene to resolve their dispute or case. Now, I understand why they like this definition better because it is more specific, but there are some things that are happening in ODR, particularly the use of artificial intelligence or algorithmic decision-making that don't fall within this definition. So it's a little bit more narrow, but this is the way the courts think about ODR, an online collaborative workspace where parties can come together to find a resolution for their case. Now, the last point I want to make, I just will reemphasize, ODR and ADR are the same. What we want to achieve when we mediate face-to-face is the same thing we want to achieve when we mediate online. And everywhere that mediation is relevant in the face-to-face world, it is also relevant in the online world. But there are some new challenges, practice challenges, technological challenges, and ethical challenges that come from doing dispute resolution online. And that's what we're going to talk about today. Catherine, please.
Could you please show again the slide?
Sure. This is the National Center for State Courts. Sure, please.
Λοιπόν, το Εθνικό Κέντρο για τα Δικαστήρια των Κρατών, μελών των Ηνωμένων Πολιτειών, χρησιμοποιεί μια άλλη ορολογία για το ODR, θεωρώντας ότι είναι ένας διαδικτυακός χώρος, ένας κυβερνοχώρος, ο οποίος αντιμετωπίζει το κοινό και στον οποίο τα μέρη μπορούν να συμφωνούν να λύνουν την διαφορά τους ή την υπόθεσή τους. Next.
Great. All right.
Άλλη μια φορά, το ODR είναι ADR. Διότι ο κύριος Ρουλ θέλει να μας πει ότι ο ορισμός που δίνει το κέντρο που σας είπα προηγουμένως των δικαστηρίων δεν είναι απολύτως αληθής, διότι δεν λαμβάνει υπόψη του την εξέλιξη που υπάρχουν στα διαδικτυακά μέσα και γι' αυτό θα μας εξηγήσει ορισμένα πράγματα που θα το καταστήσουν σαφέστερο.
Great. So you may have seen a diagram like this before that shows all the different kinds of dispute resolution techniques, from direct negotiation, where the parties are completely in control, to mediation, where there's a third party who doesn't control the outcome, but they do control the process, to then arbitration and even private judging. And when we are designing dispute resolution systems, we have to choose which of these tools is appropriate for the needs of each individual dispute. Okay, Catherine.
Thank you, Colin. Before I translate, I would like to put a question to the participants who
Please.
react to the translation, and then come back.
No problem.
I want just to read what they say. Colin, they say that they understand you perfectly.
Okay, great. That's
Second, they ask me to resume in Greek, to make a resume. They suggest that I translate later or in another channel. It is not necessary that we translate each sentence because they lose the continuity and their interest. Now, there is one question in English. My question concerns the following issue. Which is a safe way? Okay, this is a question for you, Colin.
sure.
Now,
I'll look in the chat.
now I will put the question and ask the participants to see what the majority wants. Αγαπητοί συνάδελφοι, το να μεταφράζω είναι μία πρόσθετη υποχρέωση για μένα, την οποία κάνω ευχαρίστως για σας. Διότι έχω αντιληφθεί, μετά από τις διαλέξεις στα αγγλικά, ότι κάποιοι δεν είστε χαρούμενοι. Και γι' αυτό αποφάσισα να μεταφράζω. Εάν δεν θέλετε και αυτό σας σπάει τον ηρμό ή τα νεύρα, δεν πειράζει, καλύτερα να μην το κάνω. Λοιπόν, μπορείτε να μου πείτε, σας παρακαλώ, γράφοντας στο chat μία λέξη. Ναι, όχι, ναι, όχι, όσοι παρακολουθείτε, για να δούμε τι θέλει η πλειοψηφία.
Okay. I saw there was an excellent question about signing agreements online. And I see you're getting some votes now, Catherine. So I posted some links for services that enable online signatures.
They do not want translation. So I'm free to follow you.
You're free. Okay. Excellent.
To follow you better.
you still get you get points for the translation you provided. So thank you, Catherine. All right.
Thank you too.
All right, let me go back to my slides here. All right, I will continue to speak slowly, and if anything doesn't make sense, Catherine, please interrupt me and let me know.
Yes.
Okay, so an excellent question about signing final agreements. I put some links into the chat for popular e-signing platforms that mediators use in the United States. There may be others in Greece. If anyone has links, please share them in the chat. So I mentioned this resolution matrix, which we're all familiar with because you're all trained mediators. But the point I want to make is that online, not only do we choose between negotiation, mediation, and arbitration, we also choose the ways that our parties communicate with each other. Do we want them to communicate in a synchronous format, like video, like we're doing right now? Or would we prefer that they communicate via text, which is an asynchronous format, like a chat message or an email? And you may decide you want to begin your dispute in one channel, maybe text-based, and then you want to later move to a synchronous channel. But there are pluses and minuses to all of these different communications channels. And we need to get smart as mediators about which of these are best for our parties at any given time. So the kinds of online dispute resolution processes are very similar offline and online, but there are some big differences. Mediation and evaluation, those are human-powered processes with a third-party neutral, a mediator or an arbitrator. And technology can give new capabilities to mediators and arbitrators, but fundamentally, the processes work the same way they do offline. But one of the things that's very different online is what we call problem diagnosis, the ability for disputants to engage a software program and learn about options for resolution and set their own expectation around what a fair resolution might be. And I will show you examples of all of these. The other is direct negotiation. Now, we know how people negotiate. When you have two people with different interests, they will make offers back and forth to try and find a resolution. But we can use technology to manage and shape a negotiation to make it more effective. And if mediation is just assisted negotiation, there is a way for technology to also assist a negotiation. So I will show you an example of this. But we get access to disputes much earlier in online environments than we do face-to-face. So as Catherine mentioned, I did hear this, Catherine. You mentioned that I worked at eBay and PayPal, and
Yes,
I built the resolution center there, which resolved when I left in 2011 about 60 million disputes per year. I bet that number is higher now. And 50% of those disputes were resolved amicably, meaning the buyer and the seller worked out an agreement by mutual acceptance. And 90% of those disputes were resolved in software. So no human from eBay or no third party had to touch the case. It was only software working with the two disputants. And the reason why we had to do that was because we had so many disputes. And I think the reason why a lot of courts became very interested in ODR was because they wanted to also resolve most of their cases in technology. So we actually spun out the technology from eBay and we started to deploy it in my company Modria in other areas. So we did other website disputes. So now eBay has a resolution center, but also now Airbnb has a resolution center and Uber has a resolution center. Many other dispute resolution centers have arisen for online e-commerce websites. But also now people are using ODR to resolve offline consumer disputes that occur face-to-face, but the resolution is online. We did ODR for the insurance industry. We did ODR for property tax appeals, was a huge area for us. Also, we had product liability cases, but eventually we were acquired by a company that works with the courts. And now the courts are deploying ODR very, very quickly, not only in the United States, but around the world. These are some of the courts in the United States that have deployed online dispute resolution. And there are many more than this. I think now in the United States, we have something like 75 courts that have launched ODR. Some of them are statewide, an entire state like Utah and New Mexico. Some of them are a county, which is an area inside of a state like Orange County or Yolo County in California. Some of them are using my software, Modria. Some of them are using another piece of software called Matterhorn. And some of them are building their own software. And we are seeing a lot of experimentation now trying to resolve low-value civil claims with ODR in the courts. Now, some organizations have started to promote ODR very aggressively as a way of expanding access to justice. The American Bar Association, which is the largest bar association, has a working group on ODR. The National Center for State Courts on the left here, they have written many papers and reports promoting ODR. And the Pew Charitable Trust, which is a very large foundation, they have actually put $250 million behind promoting online dispute resolution in the courts. So many courts have launched ODR because they would like to get some of that money from Pew. They are also funding 3 research teams at Harvard, the University of California, and the University of Arizona to study court ODR to make sure that the resolutions achieved via court ODR are just and durable, meaning they will last even after a resolution is delivered. So there's a lot happening in the US right now. I would say mediation in the United States is very fragmented. Every state has their own regulations for how mediation works. This map here, where some states are a shade of gray that are a little darker, those are the states that have adopted what is called the Uniform Mediation Act. So that is a law that protects mediation from discovery and protects the rights of mediators so that they cannot be prosecuted in a legal case. We do not have that in every state. So states like California and Texas and Florida and New York, which are very large states, they have not adopted the Uniform Mediation Act. But the challenge with online mediation is it's very easy for cases to cross boundaries. Maybe the disputants are in different states, so the rules are different. Or maybe even the mediator might not even be in the United States. Maybe they will be in Greece, maybe they will be in Canada, maybe they will be in China. So the way that mediation is regulated in the United States is not keeping up with the evolution of the internet. So now we see international organizations stepping up to provide consistency and standards for online mediation, not only in the United States, but around the world. So the demand for ODR is very global. And we are now seeing in British Columbia, Canada, they have launched an online court called the Civil Resolution Tribunal, which is growing very quickly. The United Kingdom has launched Her Majesty's online court, where the parties never have to show up in person. They can do it all online. UNCITRAL, the UN agency responsible for harmonizing global laws, they had an ODR working group for 7 years that recommended the use of ODR for cross-border disputes. And in the wake of that, the European Union adopted an ODR regulation that requires businesses, online businesses, to provide ODR to their consumers. But we are now seeing ODR take off in places like Brazil, in places like India. I believe that India will resolve more than 1 billion disputes per year using ODR within the next 3 years. and Singapore has started online courts. China has created what they call internet courts. So ODR programs are growing around the world very quickly, and the pandemic has accelerated this enormously. Just yesterday, I was on a call with some senior judges in Israel, and they are deploying online dispute resolution within their courts and building it specifically to meet the needs of Israeli caseloads. So I am curious to hear more about what's happening in Greece, but it is inevitable that these tools and techniques will eventually make their way into the judiciary. All right, now Catherine, I'm going to stop after this slide, and I'm going to ask you if there are any questions or reactions on your part, and then we can move ahead and I'll show you some more examples. But I have written a lot about how the ODR process is like a staircase. And you can think of each of these components like Legos. And when your parties come to you with a dispute, you can build them an appropriate resolution process in an online environment by using these Legos. You may decide, I don't need negotiation or evaluation. I'm just going to do problem diagnosis and go straight to mediation. Or you may say, I'm going to use negotiation as a first stage, skip mediation, and go straight to evaluation. But these components can be combined to build an appropriate resolution process for each individual dispute, customized to the needs of the disputants. And the first two components, diagnosis and negotiation, that is software only. There's no third party, no human third party. But in mediation and evaluation, you bring in a human third party, a trained mediator. And notice I do not say arbitration, I say evaluation, because you can evaluate cases in a non-binding way in addition to binding arbitration. So Catherine, let me leave it to you to react and translate if you think that anything needs to be translated.
No, I will not translate because I'm very glad to say that all participants follow you 100%.
100%. That is music to my ears. Thank you, Catherine. Okay, then I will proceed. So let's talk about examples of each of these. The first is problem diagnosis. Now I can show you many examples of how this works, but you can think about it as an online wizard, sort of an online workbook that parties can access 24/7. They can visit this website and they can ask questions and they can educate themselves. How long will the process take? What information do I need before I begin? What is the likelihood that I will win if I take the case to an arbitration? What are the steps? So these kind of diagnosis wizards, people are very comfortable using these tools on the internet. And you do not have to provide any personal information to access an online wizard. This one we built for a government agency in the state of Ohio. And parties can come in and they can click through it and answer questions. And they have to decide, do I want to proceed and file a dispute, a formal dispute? It may be after going through the wizard, they decide, you know what? I'm not going to do it. It's going to take too much time and it's just not worth it. So these wizards are getting very sophisticated. And most of the time, as a face-to-face mediator, when the parties come to me with a dispute, they have already been negotiating against each other. And they've reached a point of impasse. And that is why they're coming to me as a mediator. The beauty of these diagnosis wizards is you can work with a complainant before they notify the respondent that they have an issue. And that means you can influence their perspectives on resolution before they take a position. Because once the parties take a position, it can be very hard for them to back down. So I can show you examples of live diagnosis wizards, but to me, this is one of the most powerful aspects of online dispute resolution, because most of the time in face-to-face dispute resolution, they are already past this point by the time they reach out to a mediator. Now, number two is negotiation. Obviously, we negotiate all the time. We negotiate with our spouses, we negotiate with our kids, we negotiate with our coworkers. But technology can do a lot to structure a negotiation to make sure that it remains productive and the parties don't get caught in threats and insults and escalation that makes resolution more difficult. For instance, you can have software take settlement offers from one party and then share them with the other party. You can also have algorithms evaluate a case and say a fair resolution might be this. Is this acceptable to the two sides? You can have parties explain their problem by picking issues from a menu. So they say, okay, here is the dispute. Here are the details. Here is my evidence. And here are the resolutions I would be willing to accept to close the case. And then the counterparty can go in and review that information on their own time. They can take as much time as they like to think about it. And then they can say, yes, I'm willing to accept this resolution, or I would like to offer this resolution, but I would like to pay a little bit less. We found at eBay, the complainant was the aggrieved party, the buyer. And if you give them an open text box, they will often engage in threats and insults with the respondent, who is the seller. And we found that the tone of the first message was highly correlated to whether or not the parties would be able to reach an agreement by mutual acceptance. So what we did in the software was we took away the open text box from the complainant. And we asked the buyer to tell us their problem by selecting options from menus, very, very detailed lists of problems and solutions. And by doing that, we kept all of the threatening language out of their post. And then the first open text box was actually given to the respondent, the seller. And we would coach the respondent on how to communicate with the buyer and say, I'm so sorry you have had this experience. I am committed to your satisfaction. Let's find a solution together. And we found by making that technological change, we increased the rate of resolutions by mutual acceptance by 25%. So that's an example of how technology can structure and shape a negotiation to make it more effective. Okay, happy to answer more questions about that. Now, we are mainly talking about mediation today, and there's a lot of software now available to enable parties to mediate and resolve their cases online. I will put some examples in the chat of the platforms I like best. But it can give mediators a lot of new power to be able to communicate via video chat or via text chat, to share documents. You can even caucus with the parties, have a private conversation with your parties. At the same time, you have a joint conversation with them. And you can have these three conversations going all the time, which means you can caucus with your parties even when the discussion is going well, which is something you cannot do face-to-face. You can also have a library of solutions that have been achieved in similar cases that the parties can consult and use if they like to. And you can track all of the issues in a mediation to closure. So I can show you some examples of how that works. But I know many mediators who were very skeptical about mediating online, who then moved online because of the pandemic, and now they love working online. And they say they will never go back. Even when the pandemic is over, they will continue to work online because it helps their parties be at their best. It helps the prevent escalation from occurring in a mediation. And it's just more convenient and cheaper for the parties and the mediator to participate. You can resolve a dispute sitting by your pool with a glass of wine next to you, as opposed to having to take a whole day and sit in a face-to-face room. Now, the last one I'll mention also is evaluation. We run the largest case volume for the American Arbitration Association, which does insurance cases. And these evaluative processes are expedited. They only take 15 minutes. And in this case, the arbitrators can click some options in a form and the software automatically generates their award. So it's very efficient, much less time consuming, and it's very streamlined. So all of these components can work together to build an effective online dispute resolution process. You can use only one, like problem diagnosis, or you can use all of them. But the earlier you resolve the dispute, the better, because it saves frustration and it saves time, and it also minimizes costs. So why don't I stop there and see, Catherine, do you have any comments or questions, or does anyone else have any questions they'd like to ask?
Sergio will answer to you.
Great.
Colin, because he's following
Monitoring.
the...
Great.
No,
Sergio.
We don't have any question yet. Usually they ask at the end of the lecture.
No problem.
No,
Sounds
no,
good.
I think, Sergio, forgive me. There is one question which was put earlier, much earlier.
Sorry, I didn't see that.
I did see that.
Mr. Colin, I
Yes,
understood
please.
well. You said that we use ODR for low-cost cases or something like this. Do you think that mediation for disputes concerning a high level of money cannot be resolved via ODR?
That's a great question, Paulie. Thank you for that. I will say when I first started doing online dispute resolution, I thought the sweet spot was low value cases. And when I was at eBay, again, I was focused on low value cases. Our average transaction value in a dispute was only $75. But I think the pandemic has changed that quite a bit. Now I see online dispute resolution being used for higher dollar value civil cases. For instance, the average value of a case at the American Arbitration Association's New York no-fault program is about $30,000. But now what we're seeing is all of the arbitration institutions, like the International Chamber of Commerce, the London Court of International Arbitration, the Cairo Regional Center for International Commercial Arbitration, they are doing their cases online as well. And some of these cases are millions, tens of millions, hundreds of millions of dollars. I now have heard about oil and gas disputes worth almost $1 billion being resolved online. So I think my initial instinct was it was for civil cases, low dollar value, transactions between strangers like e-commerce. But now that has changed. One of the hottest areas for online dispute resolution now is family disputes. We're seeing so many family platforms crop up in the United States. I'll give you some examples. It's over easy.com, blissdivorce.com, hellodivorce.com. Those are only in the United States, but these are online divorce and mediation separation platforms. There's also other sites like coparenter.com. And yep, there are a lot of sites that deal with not only the separation, but also the post-divorce custody and co-parenting management, which is also dispute prevention. So what we are seeing is, I used to think it was low dollar value transactional disputes between strangers. That was best for ODR. But now we are seeing more emotional issues like workplace disputes and family disputes resolved through ODR. And we are seeing higher dollar value cases as well that are being resolved online with video conferencing. JAMS ADR, which is one of the biggest commercial arbitration firms in the United States, jamsadr.com, I think. They actually have resolved hundreds and hundreds of disputes over the last few months using technology. And these are very high dollar value complex disputes. So I think now everything is online. Okay, let me jump back to my slides. I will save some time for questions at the end. We are going for 30 more minutes, right, Catherine?
Yes, okay.
Okay, great. Sounds good. So let me just show you a few other things, and then I will open it up and we can have a discussion. I posted a link to odr.info. That is the National Center for Technology and Dispute Resolution, which is from UMass Amherst. That is really the home of international online dispute resolution. Actually, you know what I will do is I will take a moment to jump over there, and I will share my screen because I think this will be interesting. This is hello sign, but let me show you odr.info here. odr.info. I will shrink my screen so it's not too difficult to read. But what you can see here is we have fellows all over the world under NCTDR. And when you look at our list of fellows, you can see they are on all 5 continents. And they are working in many, many different languages. I do not believe, we do, Petros is in Greece, and he works very closely. I don't know if you know Petros, but he does a lot of work.
Yes,
yeah,
I know him very well.
using ODR, right. But there are many, many different websites around the world. Let me show you first here. We have a list of the providers. These are the companies that are providing online dispute resolution services right now. And you can see there are many, many, many of them all over the world in different languages. And I know Petros's company is on this list here. But what you can see is it is truly global. And many of these companies are taking very different approaches in terms of how they provide services. Petros, I know, has built a mobile app for doing online dispute resolution, which is very impressive. So, but what we also have is we have regional ODR sites. For instance, ODR Latino America. Oh, no, I misspelled it. Latino America. This is run by a gentleman named Alberto Elisavetsky. ODRLatinoAmerica.com. I'm going to say accept the risk and continue. Nope, that is not right. I must have the wrong URL here. Well, I'll show you another one. ODRAfrica.com. This one is based in Lagos, and it is run by my friend Morenike Obeferende. And there is a lot happening with online dispute resolution right now in Africa. And we have providers in every country. Right now, the government in China is promoting online dispute resolution very aggressively. And they are launching these internet courts all over the country to provide services online. It is now an official priority of the Chinese government to increase ODR. And as I mentioned before, in India, they are now launching some very large ODR processes. They are going to be moving all of their tax disputes online, and they're going to move all of the disputes for digital payments online. So there is the government of India is building its own ODR platform to handle all of these cases. And there is buy-in from many of the top judges on the Supreme Court. So I won't show you everything that's happening in every country, but I thought it would be interesting to jump over and show some of those sites. I urge you to explore. Here are some of the platforms that I like: immediation.com, Resolve Disputes Online, modron.com, and also crecodr.com. Those are all providers that will give you rooms that you can use to work with your parties to resolve disputes. So let me jump back to my slideshow here, because I know we're running out of time. iCoder is an international membership organization that is trying to promote ethical standards for ODR. Because there are so many new platforms emerging, it's difficult to keep track. So iCoder, we have issued a set of principles that we think govern effective online dispute resolution. And when we want this to be very simple so that mediators understand them, arbitrators understand them, but also these ODR providers who are writing the software, they must understand these standards as well. So you can go to iCoder, and these are freely available on the website. But we talk about accessibility. It must be easy for people to find and participate in ODR. It should not cost them too much money, and they should be able to access it on both mobile devices and on their desktops. And also they must be able to access ODR if they have different physical ability levels. For instance, if they are visually impaired or if they are hearing impaired. So we talk about accessibility, confidentiality, legality, security, and this is very important, making sure that the data is protected so that unauthorized people cannot access it. We talk about equality, treating people with respect and dignity. We talk about being fair, impartial, and neutral, so there's no bias in the system. And we also want the system to be transparent, meaning parties must know exactly what they are signing up for when they agree to participate. So I actually have some ethical dilemmas here, but I'm not going to do them because I want to hear your questions. But there are many things that practicing online can create new challenges for mediators. For instance, imagine you are in the middle of a mediation between two parties, and then it's taking forever to get a resolution. So you type one of the parties' names into Google and you discover that they have committed a crime in the past. This is a family case, so maybe you find out that the husband in the dispute actually spent time in prison for child abuse years ago. Now, the parties have not said this to you. The parties have not mentioned this at all, but you went out to Google and you found out this information. So the ethical dilemma is, what do you do now that you know this? Do you have an obligation to tell the parties that you discovered this, even though they never told you? Do you have an obligation to recuse yourself from the mediation? Should you withdraw because you can no longer be impartial now that you know this? Should you offer to give the parties a new mediator and not explain? Should you go and tell the husband that you discovered this information and then say, look, you as the husband, you need to make sure your wife knows about this. It may be that the two of them already know about this, but they just agreed not to tell you. So again, in a face-to-face mediation, we don't have these issues. We aren't Googling our parties when we're there with them together in person. But online, this can become very common. So I will share this deck with Catherine, with these other ethical dilemmas that emerge from ODR, and you can look at them. But we at iCoder believe we have to train mediators on how to use technology to make sure that these ethical issues do not emerge, and that mediators know how they should behave online to ensure that these ethical dilemmas do not wreck the mediation. Okay, so a few more slides, and then I will open it up. Well, this is a good question. I will say this though. Imagine you are a mediator, and you're working online with your parties on a very sensitive mediation. But then you log into your computer one day and it's behaving very strangely. It's going very slow. So you run an antivirus program and you discover that your computer has been infected by a worm. But the antivirus program is able to erase the worm from your computer. But it indicates that this worm means that someone could have been capturing information from your computer. Maybe they were reading your emails, maybe they were getting your password, maybe they downloaded files from your computer. Now the question is, do you have an obligation to notify your parties in the dispute that your computer has been infected? Because it may be that some of their information was copied. Do you have an obligation to disclose this to them? Now you may think, well, it wasn't serious, and who knows? I did erase it. I'm not going to tell them. But what we say in our ethical standards is you do have an obligation to inform your parties. And if you have information on your hard drive about the disputes that you have been resolving for the past few years, if your computer is infected and maybe that information was accidentally disclosed, you probably have an ethical obligation to go contact all of those parties from past cases, even though they are closed, because a bad guy could have gotten access to the information from their case. So again, information security is very important in the online environment. So let me just wrap up by saying we need to have ethics not only for mediators and arbitrators, but also for the people who are writing the software themselves. So we are writing ethics that govern not only individual third parties, but also administrators. And the other concept that I would like to share with you is this idea of the fourth party. Technology as another player in the dispute. You can picture it as a happy little robot if you like, but the technology is sitting at the table with you and with your parties. And it is your partner. The third party and the fourth party must work together. And if it works well, it can be very effective and save a lot of money for the parties and for the mediator. Already, we are relying on the fourth party to do these things, to enable our parties to file a case with us, or process our payments, or send out reminders, or manage our documents, or have calendars, or even with Zoom. Right now, this is the fourth party. It is structuring this conversation and helping it take place. But the real question is where we are going to be tomorrow, because technology is getting smarter and more powerful every day. We are about to enter the era of quantum computing, where computers will become unimaginably more powerful than the computers we have today. So then we will ask our computers to do things like research in our cases, coaching our parties, reframing communications, enforcing outcomes, evaluating evidence, maybe even drafting documents and submitting those documents to a court. And we may at some point have a digital mediator or a digital arbitrator. But the real question is not where we are today, it's where we are going to be tomorrow. My grandfather always said to me when I was growing up, he said, Colin, do not build your business where the highway is. Build your business where the highway is going. And that is why all of us in the mediation field need to get smarter about technology so that we can continue to evolve our practice as society evolves its use of technology. So I'm going to jump to the end because I want to hear your questions. I will say there are some very exciting technologies coming around the corner. Things like machine learning, artificial intelligence, blockchain, which is the ability for people to create an agreement and put it into an online blockchain where it cannot be changed. So that delivers a lot of trust because you do not have to debate about whether or not this agreement is accurate or not accurate, because if it's in the blockchain, it cannot be changed. Also, smart contracts. So when we reach an agreement, instead of signing a piece of paper, we create a little bit of computer code that lives in the blockchain, and it automatically administers our agreement as we move forward. So all of these things are coming. I see them here in Silicon Valley, and they are all very related to what we do in the dispute resolution field. So I think it's important that we all be open to these possibilities and we learn about them. They are just new tools for our toolbox. It doesn't mean we have to use them, but we need to understand when they can be valuable and have them in our toolbox so that we can help our parties with these solutions when it is appropriate. Okay, I think I've said enough. I'm tired of my voice. I want to hear more beautiful Greek from all of you. So please, does anyone have any comments or questions or thoughts? Kostis, did you raise your hand?
Yes, thank you so much for the presentation. It was very interesting.
Great.
Really gave new horizons to us. I would like to make a few questions and I will try to wrap them up as quickly as possible.
Please.
First of all, I should say that I'm a big fan of yours, despite the fact I never make a deep search on who made the eBay Dispute Resolution Center, but I've used it in many ways because we have the same alma mater with the old CEO of eBay.
So, nice.
When he came to the university and talked to us, he gave a huge, a big presentation about the very successful ODR system that eBay had.
Wonderful.
And two questions I would like to pose to you. One is how can we sort out the CQ problem, the cultural intelligence problem? Because when we try to mediate in front of the computer, far away from each other, it's difficult to understand if that's acceptable, that is not acceptable, that's outside the lines. Second question I would like to make to you, and it's an example of CQ. When I was sitting for the exams for the New York bar, my worst class, and I never thanked the professor then that he really helped me to go for the bar, is the ethics. And I was trying, and I'm actually reading now the ethics of the New York bar because I'm trying to update our policies. So I was reading some punishments they have for a lawyer that was not doing their job the way they should do, and it was like a punishment for a month or two. And I was trying to understand what stupid punishment this would be, because I was thinking like for a month it's not a punishment.
Right.
And then I was trying
it's a vacation.
And then yes, and then he explained to us that a month is it's a real ban from the income, it's a ban from everything. So it's not like the Greek way. When I came back, I tried to, I'm also in the information committee of the Athens bar. So we're trying to improve some of the systems that we have on the lawyer side, trying to persuade the government to do something more. And I tried to search offline, of course, because we don't have online, the punishment for the ethics. And there are no official judgments. There is no ruling. There is nothing. So my question is very clear. And how do you think that, because maybe you have an example in other countries, how can we save the honor of the mediators in a new market like this? Because if we lose now the moment, and we are being held as just the new thing coming, but we fail to ensure that what we're doing is consistent with our policies, our ethic rules and everything. I think that the mediation will just take the blame on us, which it's not its fault. So how do you have an example from other countries? How can they create a solid system of rules, punishment, quality control, whatever you've seen working in other countries?
Well, Kostas, these are great questions. Let me start with a cultural one, because I think that this is very important. You know, online practice enables us to work around the world. And many of the disputes that I've been asked to resolve, they may be about a transaction, but in fact, there is a cultural component, because the way that the two parties are trying to resolve the dispute, they bring certain cultural assumptions. And if there's a disconnect between those assumptions, that can create conflict. So there's rich scholarship on culture and negotiation styles. I think online dispute resolution, sometimes it's harder to pick up on those cultural differences. You know, there may be norms in Greece that are very different than California. And I may engage in negotiation with you, and we might behave differently because of those cultural expectations, and that may make achieving resolution more complicated. And that's why it's important that we have mediators that are aware of these cultural dynamics. If we had a Greek American who could serve as a mediator, well, then they could help to translate some of these cultural expectations. I do think also there are new cultural norms emerging on the internet. At eBay, we had new norms that emerged, and it didn't matter if the buyer and seller was from France or Korea or Argentina or Greece or California. On eBay, you know the rules. And what that means is if you don't follow those rules, even if they are different than the norm in your home country, people will give you bad feedback. So I think that we are seeing a very interesting evolution in online culture that will affect the way that people engage in dispute resolution. So that we could do a whole day just talking about your first question. So thank you for that. But the second one with ethics rules, you know, this is a very tricky issue. In the United States, mediators are not regulated like lawyers. Lawyers, if you took the New York bar, you know, lawyers are regulated state by state. You have to take an exam and you have to take a certain amount of continuing education. And there are a lot of ethical rules. If you don't follow those rules, you can be disbarred. And in the United States, anyone can be a mediator. Even if you've never had a mediation training, you can say, I am a mediator. And there is no board, there's no bar, ethics bar of mediators that can say to you, no, you cannot call yourself a mediator. I actually know a clown in San Francisco. He is a big fat guy who dresses with makeup on his face, and he carries a whip, and he calls himself Ouchie the Clown. And he says, I provide many services. I do singing telegrams, I do bachelorette parties, and I do mediation. And when you look on his website and you click mediation, all it says is, so you've never had a clown mediator? Well, give it a try. So no one can say to Ouchie the clown that he cannot be a mediator, because there is no board that says you are a mediator and you are not a mediator. And hey, Ouchie the clown may be a very good mediator. I've never seen him mediate. But the thing is, because mediation is so unregulated, it's difficult to find the good mediators and the bad mediators. So again, we at iCoder, and if you look at the ethical rules from SPIDER, the American Bar Association, the American Arbitration Association, or even the International Mediation Association, many of those ethical rules are voluntary. You know, mediators abide by them, and they sign up for these organizations, and they self-enforce. We don't have a way to say to someone, you're a bad mediator, you can no longer mediate cases. So what I hear you saying is you're looking to Greece and saying, how can we set up a mechanism to enforce these ethical standards? I think the New York bar ethics process is a much better model than what we have in the mediation field. So do you have any follow-up thoughts on what I shared?
It's a very interesting, you know, thing that it always, the answer is always, it depends on how we can make some things work. And
right.
I totally agree with you that maybe someone that is not a lawyer can be a competent mediator because they can think easier than us outside the box.
Right.
But, you know, like one big problem that we have in Greece, and it's a topic of like the topic of the days because of the COVID. It's difficult in Greece. We are not allowing a private doctor who is licensed to practice to practice in Greece to provide a certificate to someone that to stay home and not go to work, which is crazy because we cannot even persuade a doctor who gave the oath and has very specific rules that all the doctors in the world more or less would agree on what's the level of illness or sickness.
Sure.
Make it easier. Would make someone stay home. And
right.
That's what I'm trying to you know, that's what I'm thinking, that it's very difficult. And I'm seeing that on the lawyer side, that we already lost this train. And if that's the only reason that I understand that the New York bar is something interesting, that it's like a castle and it has some rules. It's open to everyone from around the world, as long as you obey to some rules. And it's very difficult to obey to rules that are not very solid.
I agree. The rules need to be clear. If you're going to write standards, they must be clear. But I think you're taking on an important challenge, my friend. So we will pay attention. I will say I am now CEO of Mediate.com and Arbitrate.com. And when people want to join our directory, we look at their experience and decide whether or not, yes, they should be able to join. And then we also provide certification for those professionals. But again, we are not a regulatory authority. Even if we say to someone, look, you have not been trained, you have had bad complaints about your services, and we take them out of our directory, they still can provide mediation services and arbitration services. It's just we will not promote them. So it's a very interesting question. Yeah. Thank you, Kostas. Okay, we have some text questions. Poli said, thank you very much for all your answers. Practicing ODR mediation in Greece in a private manner, not via a specific ODR platform for mediation, but via Zoom because of COVID. I find that sometimes I feel comfortable to prepare my session using the phone, even between two sessions. In my opinion, we can do it because mediation, let me mute here, Dimitris. Mediation is a manner of communication too. Do you think that is correct, or do we have to stay online mediation only? I think that's a great question. There are many studies that show that phone mediation is equivalently successful to face-to-face mediation. And it is true that you lose a lot of nonverbal communication when you communicate over the phone, but you can still get a lot of emotion and sentiment from vocal tone that you don't get when you type things out. So I think phone mediation is a great option. Sometimes people are too quick to say, let's use Zoom. And parties may be uncomfortable looking at their video on screen, particularly if it is a very emotional case. So I think the phone is a very, very powerful and often overlooked online dispute resolution option. And maybe communicating initially with parties via email, then migrating to phone calls, and then migrating to video conferencing, that may be the appropriate path for certain disputes. So Poli, I think that what you're saying is exactly right. All right, Dimitris, how are the platforms regulated? Do minimum state laws exist? Who supervises the meetings of standards such as confidentiality, GDPR, etc.? How are the settlements enforced? Are platform terms regulated? So I would say they're not really regulated. Online dispute resolution in the United States, still, there are not a lot of laws that govern the performance of these platforms. I think there are some rules and regulations around face-to-face dispute resolution, and the implication is that ODR platforms and ODR service providers will have to abide by those face-to-face rules. But I know the American Bar Association and the International Mediation Institute, they are looking to revise their ethical standards and their guidelines and rules to account for online practice because it's becoming so commonplace. And we are doing a big project at Mediate.com with all of the leaders in the field to rethink those standards of practice to account for working online. You know, things like the GDPR, obviously, that's European privacy regulation. If you are required to meet certain disclosure and reporting obligations if you do online work in Europe, and you have to abide by the GDPR. And if you are found to not be in compliance, then you could be sanctioned for not being in compliance. So, you know, many different organizations around the world have privacy standards. We now in California are implementing new privacy standards. So everyone who does ODR, we have to make sure that we abide by those international standards. Now, enforcement is a very important question because I can engage in an online dispute resolution process and I can achieve an outcome. I can say the resolution is this, but if I cannot enforce that outcome, then my parties will be very frustrated. At eBay, we owned PayPal. PayPal moved all of the money. So if we decided a buyer was entitled to a refund, we could take it out of the seller's wallet and we could put it into the buyer's wallet. If you look at like ICANN that does domain name disputes, they control all the domain names. If they decide that Costas deserves the domain name that Sergio has, they can take the domain name from Sergio and they can give it to Costas, even if Sergio doesn't want that to happen. So if you build an online dispute resolution system, you have to make sure you can enforce the outcomes. If you cannot enforce the outcomes, the system will probably make people very frustrated because they will say, you're entitled to get money back, but I can't get you the money back. Mediation is a little better because the parties agree. So presumably, if the two parties are agreeing, they will abide by the outcome that they've agreed to. But I think you're asking a very, very essential question. When you design an ODR system, you must think about enforcement. Okay. One more question from Panagiota. Oh no, they're just compliments. Oh, thank you from Vicky and from Panagiota. So are there any other questions we'd like to discuss? Dimitris, I'm getting a little noise behind. Okay, there you go. Thank you for muting. Any other comments or questions? Please, Sergio.
You mentioned earlier that in eBay and Amazon, 90% of the cases were resolved via software. Mm-hmm. This goes mediation software and arbitration software. And how do you think is the future? Is there going to be a mediator which will be not be a person but a computer? And is this computer capable to have the skills that the mediator should have?
Well, I think that, yes, we will resolve many of our low dollar value disputes via software in the future because the disputes are just too inexpensive to afford to pay for a human mediator. But I don't think that computers will work the same way that human mediators work. I think they will work quite differently. You know, the decisions that we made at eBay were often based on decision trees. So we would go in and ask questions. And then based on the answers to the questions, we would pick an outcome. Oftentimes, a computer would decide the case in all cases, but the parties could always request a human review of the case if they wanted to with one click. And what we got to the point was the software was so good and so consistent and so predictable that only 0.01% of our cases did the parties ever request a human review. So I think that is where we're going. I don't think that we're going to have a digital judge, like a Supreme Court judge, that will listen to arguments from both sides and then write a very long and reasoned decision. That's not the way computers work. But we may have a situation where an algorithm, a machine learning algorithm, the two sides come in and present their evidence, and then the algorithm says to the two sides, each of you to say what you think a fair resolution would be, your best offer for resolving the dispute. And then party A will make an offer and party B will make an offer. And then the machine learning algorithm will decide which of the two offers is fairer. And then it will go with that offer. So we call that final offer arbitration. Computers are very good at that because computers can go look at 10 million cases in 20 different languages and come up with what they think is fair. And then when the two sides put their offer on the table, the computer is just picking between the two offers. That may be the way that algorithms resolve disputes in the future. It's not the same way that humans do it, but it may be as effective, and it certainly will be much cheaper. So I think artificial intelligence, I think we are still 5 or 10 years away from that being commonplace. But I do believe in the future, we will rely on computers to drive our cars. We won't drive our cars anymore because the computers will be better and safer at it. And we probably will rely on them also to run our courts because they will be better and safer and cheaper and more consistent. That's what I think is coming.
Okay. Thank you very much.
And I've also, Poli, thank you again for the kind words. Vasiliki asked, how can a Greek mediator work for an ODR platform? Well, the first thing I would do is reach out to Petros because he's the guy who's doing the most in Greece right now. And he has a panel and he's putting things together. You can also get your own software and build an ODR solution. But you can also join many of the panels around the world. I'll give you some links. Mediation.org, netneutrals.com, onlinemediators.com. You know, and again, if you join a panel, and for instance, if there are not a lot of Greek speakers on the panel, if any Greek cases come in, those will be your cases. So I do urge you to look around and find sources of cases. Unfortunately, I don't know the landscape in Greece and the Mediterranean as well in terms of demand. I know countries like Italy have made mandatory mediation laws, and that has really skyrocketed demand for mediators. So I'm not sure where you are in Greece on those counts, but that's a good way to get more cases as well. I could go on, but Catherine, we are at time here. So any other closing comments, please, Sergio?
No problem, Colin. If you have time, it is our pleasure to keep you with us. I have one question, if I may. If there are no other questions.
Facebook, do you want to say them first or do you want to ask?
What?
Okay.
If there are no other questions, I would like to put one, but at the end.
Okay.
Sergio, tell whether there are other questions,
There are two
please.
questions from Facebook, I see. Anna Plevri asks this. Is there any development on the Singapore Convention? And if there are new countries that have signed this convention? And the second, do you believe that is it more difficult for the mediator to show empathy in the framework of online mediation?
Great questions. So many of you know the Singapore Convention on Mediation is like the New York Convention for Arbitration, but it allows for the enforceability of mediation outcomes around the world. So if you have a mediation that's achieved between two parties, maybe one's a Russian party and one is a Cypriot party, that mediation award, if it abides by the requirements of the Singapore Convention, is enforceable in many, many courts around the world. All the signatories of the Singapore Convention. And now I think there's more than 80 countries that have signed the Singapore Convention. So it's growing much faster than the New York Convention grew when it was created in the 50s. So it's a very exciting time for mediation. And we see the legitimacy of mediation rising in high dollar value commercial cases because of the enforceability of those awards in other jurisdictions. So what we're seeing now is a lot of arbitration cases actually are turning into what they call evaluative mediation cases, where the mediator will listen to both sides and render their opinion of what they think is appropriate, but it's non-binding on the parties, and the parties have to accept the recommended outcome from the mediator. So it's an exciting time for mediation. You know, there are many models for mediation. I'm a facilitative mediator, but there are evaluative mediators and there are transformative mediators. So that's exciting. And the second question, remind me, Sergio, what was it about?
This is also from Bernadette. She has the same question. If it is more difficult for the mediator to show empathy during the framework of the online mediation.
It is. It's complicated. We know 50% of communication is nonverbal. I mean, you're looking at my face now, and you're getting some nonverbal communication, but not as much as if we were in the same room. You know, when we talk about active listening and we talk about reframing, many of the core skills of mediators, it requires rapport. It requires connection with the parties. And what we get online through video conferencing is a little bit of distance, emotional distance. I remember when Zoom mediations first began, people said you should look into the camera. You should look into the camera when you talk because it helps to build connection with your parties. Now I find that is very creepy if someone is looking into the camera because you know they're not looking at your face. Your face is on the screen. So I'm looking at all of you and all of your eyes are lower. You're not looking directly into my eyes. Your eyes are lower because you're looking at my face on your screen. So now I think it has become a new norm that when you talk to someone on video, you're not going to look them in the eyes. They're going to be looking lower because that's how they see your face. So I do a whole training, a series of trainings on how to transfer your offline mediation skills online. And one of those things is how do you build that connection? How do you build that rapport? And I think there are ways to do it. You can feel a connection with someone over video, but it is very different than face-to-face. If someone gets emotional and they start to cry, you cannot put your hand on their arm. If someone gets angry and starts to yell, you can't talk them down in the same way. In video, it's very difficult for people to talk at the same time. You know, Catherine and Sergio were just talking at the same time and no one could hear anything because the audio cuts out. Whereas in a room, people overtalk all the time. That's part of the way that we communicate. So some mediators can use that dynamic to their advantage because it lets people speak in an uninterrupted way. Because you as the mediator say, I'm sorry, when you both talk, I can't hear you. We have to take turns. Catherine, you go first. Sergio, you go second. So there are a lot of different dynamics. The other thing is we have a chat here. All of you in Zoom, you could be posting messages in Greek to each other about how this guy Colin, he doesn't know what he's talking about. I would not know that. There are private messages that are happening. That is a different dynamic than what happens in the room. Well, you could do it in Greek and I wouldn't know that either. You could do it right in front of me. I wouldn't be able to see it. But the point is, online is quite different than face-to-face. And we need to understand what those differences are in order to be able to deliver effective services to our parties. So Catherine, you had a question as well. What was your question?
Yes, indeed. I have actually two questions.
Okay.
The first concerns the scale, the escalation of the dispute. Which is the point of this escalation where there are no chances anymore for any resolution?
Well, that's
the
a difficult
point where
yeah.
one says, I will get lost, but you will get lost with me.
Well, I think if the parties are not participating in the mediation in good faith, you should end the mediation. I always say, obviously, a bright line is when there is a threat of violence. If there's a threat of violence at any point in a mediation, I stop the mediation because it's not an appropriate venue unless the parties say, okay, I'm sorry, this wasn't for real. You know, you need to evaluate the reality of your disputants to see whether or not mediation is adding value. If people are just engaging in threats and insults and they are not in good faith trying to work towards a resolution, I think you as a mediator should say, if we're not working towards a resolution, we're wasting our time and I'm going to end this process. But I think that is very much in the eye of the beholder. You know, I have seen cases, family cases, where there has been, you know, there's been a threat of violence between the parties, but the family mediator has decided to proceed because he or she has talked to the parties and feels that, you know, it's still appropriate for them to engage in the conversation. Now, there's always a risk. There's always a risk of those kind of emotional cases spiraling into other channels. But I think that every mediator, that's part of your job as a mediator, is determining when it's not productive to continue the mediation any longer. And there are various factors that add into that. So hopefully that answers your question.
Thank you very much, Colin. And my second question is the following. I would like very much to know your opinion about blind bidding.
Great question. So blind bidding was one of the earliest algorithmic dispute resolution techniques. And it's where one side, one party, party A, they come in and they put in 3 bids. And maybe they're looking to get paid. These are amounts of money that I'm willing to accept to close this case. And then party B comes in and they put in 3 bids. These are the amounts of money that party B is willing to pay to resolve the case. Now, the way blind bidding works, at least at CyberSettle, which was the first blind bidding company, bid 1 for party A and bid 1 for party B are compared against each other. And there is a resolution percentage. Maybe it is 10%, 15%, 20%. If the 2 bids are within that percentage, the case settles for the median. And it is binding. It's binding that is the resolution, and the parties agree they are going to agree to the midpoint between those numbers. If the 2 numbers are not within the resolution percentage, then it goes to bid 2. And it compares bid 2. Are within the resolution percentage? No. It goes to bid 3. It compares the numbers. Are they within the resolution percentage? No. Then the blind bidding is closed and no resolution is achieved. Now, why does this mechanism have value? Why would anyone use this? Well, the value is you never see the offers from the other side. Okay, so you put in your 3 bids, they put in their 3 bids. If you do not achieve resolution, you never see the offer from the other side. Maybe they put in $1,000, maybe they put in $1 million. You'll never know. All you know is you are not within the resolution percentage. So in a negotiation, people are often very reluctant to put the first offer on the table because you are revealing something. If you come in and you say, okay, Sergio, to resolve the dispute, I want you to pay me $500. And Sergio goes, oh, $500? Okay, $500. Great, no problem, $500. I go, oh no, what did I do? Oh, I should have asked for $1,000. I should have asked for $3,000. It was too easy. I came in too low. So people are very reluctant to put the first number on the table because they don't know what the dispute is worth. Blind bidding lets you test. It lets you test with different numbers. And if you don't get a resolution, you're where you were before you even started. So I think blind bidding can be useful in very specific circumstances, usually where the parties are both businesses and they're both highly informed about the value of their case. It's much harder to do blind bidding with consumers or with aggrieved individuals, people who have been injured, because they don't know what the value of their case is. So the odds that they're going to pick a number that's within the settlement percentage is very low. But I think algorithmic resolutions like that do have value, and they can resolve a certain percentage of cases. Blind bidding has been shown to resolve 20 to 30% of cases when it's used between knowledgeable parties. So I think it's a great idea in specific applications, Catherine.
Thank you very much, Colin. But I would say that, or I would ask you,
please,
is mediation anymore?
Is there mediation anymore?
Yes, blind bidding is not a mediation.
No, it's not. Blind bidding is not mediation.
In blind bidding, the third party is the computer.
Yes.
It is not the fourth party, it is the third.
Well, that is right. I think that blind bidding is technology-assisted negotiation. It is not mediation. It is an algorithm that is used to structure a negotiation between the parties. And yes, you have to trust your blind bidding program. Say you put your bids in, you put in your 3 bids, and the computer program says, I will keep them secret. I will not tell the other side. But maybe secretly, they contact the other party and they say, if you pay me $100, I will tell you what their bids are.
Oh.
secretly, and then it reveals your bids, and then the other side will pick the absolute lowest number on the lowest bid to get the best resolution for them. And you thought that you were engaging in a trustworthy process, when in fact, on the back end, it was a corrupt process. So that's why you're right. Blind bidding requires trust. And that's why we have to govern those types of software programs with very stringent auditing and ethical regulations.
Thank you very much, Colin.
And, you know, with Catherine, with that, I think maybe let's wrap it here. People look tired. It's late in the day for all of you. And I know I don't want to just go on and on. It's only the middle of the morning for me, so I could keep going. But I wanted to thank you, Catherine, for letting me present. It's so nice to meet all of you. And I'm very excited to see what happens with ODR in Greece over the coming years. So please keep me informed and let me know if I can help with anything. I'm eager to do so. And Catherine, again, thank you for the invitation.
Colin, I thank you very much again for having accepted the invitation. And we will keep in touch, certainly. And when this pandemic will be hopefully over, we will invite you to come here in Greece.
Oh, please.
Have a meeting all together and speak about many issues, not only about mediation, but on a friendly meeting to get together.
Well, Greece is one of my favorite places in the world. I have nothing but happy memories there. And my wife wrote a cookbook about yogurt, and she visited Greece and ate Greek yogurt everywhere. So we have to come over and eat lots of yogurt. So I will definitely say yes. I see that the domain name ODR Greece is still available. So whoever wants to buy it now, because it may be worth a lot of money one day. So thank you very much, Catherine.
Thank you very much, Colin, again. All the best. Keep well, keep safe, and we will be in touch very soon.
Absolutely.
Your presentation was excellent. This is not a compliment. It was
really great. Thanks a lot.
And we thank you indeed with all our heart. Thank you, Colin.
Thank you very much, everyone. Take care, stay well, and be in touch. Okay.